Good morning, everybody, and welcome to what promises to be a very insightful webinar today on the topic of legal solutions to assist those with impaired decision-making abilities, presented by Ekklesia in collaboration with Ladybug's marketing company. So this is a very sensitive or a delicate problem, and which many of us have to face at some stage of their lives. And I think from the amount of people interested in the topic, we actually know that it is a pressing topic to be addressed. So, you know, as medical intervention improves the longevity of people's lives, they get older, the possibility of suffering from dementia increases, and thereby you get the inability to make their own decisions, to decide about things in their daily living or even for their future. So, but we are very privileged to have today Advocate Sarita Liebenberg. She told me that advocate is not really a title, but I think you need to know that she's an advocate. She obtained her BA-LLB, BA Honours degrees from the then Rand Afrikaans University. Having practiced as an attorney, Sarita was admitted to the Joburg Society of Advocates in June 2020, where she remains in private practice. Now, over the years, Sarita's practice evolved from general civil litigation practice to one which is focused on matters involving children, family, and matrimonial law. When not practicing law, Sarita juggles the responsibility of being a mother to two teenagers, and if they are by any means normal teenagers, they're definitely practicing their own decision-making abilities at this stage. And at the same time, she's also the wife of an advocate. I would just like to remind you that you are welcome to send your questions. If it is at that stage possible to direct it to Sarita, we'll do so. Otherwise, we'll make sure that after the information session, we'll ask her the questions. So yes, Sarita, welcome, and thank you so much for joining us today. Thank you.
Thank you so much for having me, for the invitation. It's an honor, albeit a different kind of audience than I'm used to. I generally speak with other lawyers and judges, so forgive me. I'm going to try my very best to use simple English and steer clear of terminology, but it's not always easy, but I'll try my best. It is, in my practice and my experience, one of the most agonizing things for family and loved ones who come to me for advice on what to do when an older person becomes intellectually or otherwise impaired to make decisions. Decision-making is such an important part of human life, because by choosing, we exercise choice through making decisions. Decisions regarding our personal welfare, our financial affairs. That's how we express our individuality, my two teenagers with their choices of decisions, and how we exert control over our own lives. But decisions are also important within the legal context, because it is people, you need to have legal capacity in order to participate fully in life. The capacity to have rights, to acquire rights, and to exercise our rights. And to hold and acquire and exercise rights involves making choices and decisions. In terms of South African law, full legal capacity is awarded to those who attain the age of majority, which since 2005 is the age of 18. So the moment one is 18 or older, you are deemed to have full legal capacity. But not everybody that is 18 or older can exercise full legal capacity, and they are unable to make their own decisions. Now, the inability or impairment in the ability, impaired ability to make such decisions may arise from various causes. It could be an injury, a brain injury. It could be a mental or a physical defect. It could be a disease, and it could be old age. It could be anything. I'm hoping to give to you today a broad outline of the alternatives available to assist those who need assistance in decision making. Please accept that I cannot give individual legal advice. It's not the intention, and my professional ethical rules to which I'm bound do not allow me to do so. Unfortunately, again, those professional ethical rules, you cannot contact me directly for assistance. It's got to come through an attorney. And by saying that, I'm not advertising, please. Now, the moment somebody becomes, the ability to make decisions becomes impaired for whatever reason, they are at a disadvantage. And society expects from us as lawyers and the law to address the needs of those people. Now, as I said, it is very often loved ones who realize that the older person, and I focus on older people today, that their ability is impaired. Now, that realization is agonizing. It is fraught with emotional turmoil, with concern about that person's physical welfare, but more so the financial implications of an impaired decision-making ability. Now, just to take a step back to why legal capacity is so important and the influence of mental impairment on legal capacity. A person who lacks legal capacity cannot perform valid legal transactions. And that's a contract, that's buying anything, that is enrolling in or seeking to come live in Ekklesia Park, to execute a testament, a will and testament. Those are all legal transactions. And if a person lacks legal capacity at the time of entering into such a transaction, that transaction is void from the outset. It is a legal nullity. And it cannot be ratified, that is made good and validated later on. That doesn't matter whether the other person to the other party to the transaction realizes this or not. A person with a lack of legal capacity cannot enter into a legal transaction even with the assistance of another person. So unless that person is authorized. And authorization within the context of South African law is actually few and far between. Now, when an authorized person enters into a transaction on behalf of his or her, and it's a term that is used, a charge, his charge or her charge, the patient, then it is a legal transaction. But one cannot obtain more rights, acquire more rights, or give away more rights than the charge or the person under curatorship has. People are generally presumed to have full legal capacity. And if somebody alleges that that a person doesn't have it, you must prove it. And that is generally by way of evidence of the surrounding circumstances. And just because a person at one stage in entering into a transaction doesn't have legal capacity doesn't mean necessarily that he doesn't have capacity some other point in time, or what we call a lucid moment. The Latin for that, I love Latin, a lucidum intervallum, a lucid moment. Now, let me start off talking about a power of attorney, because many people foresee that the time may come where they can't make choices, decisions, and they want to cater for that eventuality. An obvious way of doing so is to authorize a trusted person to make decisions on your behalf. And that is often done by way of a power of attorney, which is nothing more than a written declaration by the principal, is the term we use, the person who now gives the authority is the principal, to the agent, the person who is then authorized, to perform on behalf of the principal specified acts. Or the declaration, the authorization can be specific or more general in nature. That's when we speak of a specific power of attorney, very often in the context of when immovable property is being transferred. One is required to give a specific power of attorney to the conveyancer, the attorney, to do what needs to be done to pass to effect registration of transfer. Or it can be a more general power of attorney. But under our common law and our current law, a power of attorney is immediately terminated once the principal becomes disabled, impaired. It follows that a principal cannot authorize an agent to take care of the principal's affairs after the principal has become a person with a disability. This no doubt comes as a shock. Most people do not realize that in South African law, there is no such thing as what is termed an enduring power of attorney. In other jurisdictions, other countries, there are laws to that effect, that even if the principal becomes, for instance, older, has a stroke, whatever the cause might be for the disability, that power of attorney endures. I've seen it how often in my office where people come and say, oh, but the bank no longer allows me to transact on behalf of my mother or my father, but I've got a power of attorney. And this is where South African law is out of step with other legal systems. Now, the South African Law Reform Commission many years ago started with various projects of investigations on assisted decision making. And already in December of 2015, it's 8 years ago, published a discussion paper catering, amongst other things, and discussing, amongst other things, the introduction of enduring powers of attorney. Well, nothing's happened. So that doesn't exist. So within the context of South Africa, there is no single comprehensive source dealing with decision-making impairment and the assistance for such people suffering from that. We have to, in South African law, look towards two sources. The common law, that is not in legislation, and then those in legislation, where legislation provides for assistance. Now, within the context of the legislation, and I'm talking specifically only about older persons, there are other aspects, other pieces of legislation dealing with other people with impairments and with children. But in the context of older people, one has to look at either the Mental Health Care Act, and I will discuss the process provided for in that act in depth. Then there's the National Health Act, which in section 7 to 9 of the Act allows for, well, this deals specifically for medical treatment, that a user must consent, give informed consent, unless somebody else is mandated. So that person, again, the agent, can be mandated by the patient in writing, or that agent can be authorized by court. So if that person gives the informed consent, then a doctor, medical treatment can be afforded and administered to the patient. So that's the Medical Health Care Act. There are certain things to which people cannot consent in terms of the Medical Health Care Act, and that, for instance, is the donation of blood or tissue from a living person, a living patient. You cannot consent to that as an agent. In terms of the Social Assistance Act, SASSA can nominate a person or a welfare organization to whom the grant is paid on behalf of the incapacitated person. And then in terms of the Older Persons Act, and one would have thought that that act, the Older Persons Act, would cater better for these, for older people with impaired decision-making capability, but that's not so. But what the Older Persons Act does allow is for alternate consent, that's by an agent, for the admission of an incapacitated older person to a facility providing accommodation. So, for instance, in the context of Ekklesia Park, I would hazard a guess that a child can assist in placing a parent, admitting a parent to Ekklesia Park, if that patient, that older person, is incapacitated. So that's the statutory framework for assistance. And in terms of the common law, there is provision for the appointment of a curator, placing somebody under curatorship, having a court having declared that patient incapable of managing his or her own affairs. and then for the appointment of what is termed a curator. So for purposes of a more comprehensive assistance being provided to a patient, there are really two ways of doing it. The one is for the appointment of an administrator in terms of the Mental Health Care Act, or in terms of the common law and the rules of the High Court, the appointment of a curator. Now, I need to preface what I have to say about the Mental Health Care Act as follows. That procedure bypasses, if you will, involving a court. It is the master that decides and considers an application. Where that being so, there is no judicial declaration of incapacity. So in terms of the Mental Health Care Act, it's not that the patient is declared incapable of managing his or her own affairs. Where in terms of the common law, it is a court, the High Court, not the Magistrates' Court, the High Court, who determines and declares somebody incapable. I have concerns from a personal point of view about appointing an administrator without judicial oversight, because it affects somebody's legal status. You are taking away the power a person has to manage his or her own financial affairs and putting it in the hands of somebody else. And I need not say it, but I am going to say it. It is a process open for abuse. So those are the two processes. Now let's deal with the Mental Health Care Act. It's a relatively simple process whereby the Master of the High Court, now the Master of the High Court is an office that is set up in each division of the High Court. So we have the Master's office in Johannesburg, we have the Master's office in Pretoria, Polokwane, Durban, and so forth and so on. And the Master has very specific duties, powers, and a role to play. And the Master is especially relevant in matters concerning people's estates. That is whether it's in the context of an administrator, whether it's in the context of the appointment of a curator, or then in terms of a will, when somebody passes away and the will the estate has to be wound up, the executor does so under the auspices of the Master's office. Now, the process in terms of the Mental Health Care Act relates to the property of a person who is incapable of managing his or her own property due to mental illness or by virtue of severe or profound intellectual disability. So it's only those, in terms of the Act, it is only those two categories of persons to whom an administrator may be appointed. Now, a mental illness is defined in the Act as a positive diagnosis of a mental health-related illness in terms of accepted diagnostic criteria made by a mental health care practitioner authorized to make such a diagnosis. And then the definition of severe or profound intellectual disability means a range of intellectual functioning extending from partial self-maintenance under close supervision, together with limited self-protection skills in a controlled environment through limited self-care and requiring constant aid and supervision, to severely restricted sensory and motor functioning requiring nursing care. The question is, for instance, a condition such as dementia or Alzheimer's disease. Does that qualify as a mental illness? And in my experience, in acting as a curator ad litem to patients, that's not necessarily so. It's not necessarily a mental illness. Yes, there's intellectual disability, but is it necessarily as severe or profound as the Act defines? That's a different question. But those are the two categories of people to whom an administrator may be appointed. This means, and says the Law Reform Commission already in their discussion paper, it doesn't cater, for instance, then for people who need support because of a stroke or a brain injury or as I say, dementia. Furthermore, the Mental Health Care Act relates only to the administration of property by the administrator. And it does not cater for assisted decision-making regarding the impaired person's personal welfare interests, whether it is a consent to medical treatment or alternate accommodation. But once an administrator is appointed, his or her powers and duties are much like those of a curator bonis that is appointed by the High Court in terms of the common law. And the powers and functions broadly correspond. Now, the bargain, if you will, that comes in with an application in terms of the Mental Health Care Act relates specifically to the costs of the application itself. It doesn't involve the court, as I said. So one saves money on appointing attorneys, on appointing counsel, advocates. So I'm not going to earn any money, but that's fine, because any person who is older than 18 years can make an application to the master. And the application, which is under oath or affirmation, is, I understand, 3-4 pages long. I've never seen it because I'm never involved, because it doesn't involve lawyers. But it's a fairly simple application. As one would do in the High Court, you've got to set out as an applicant, you who make the application. If you're not the spouse or a next of kin of the patient, why do those people not make the application? You've got to state then, if you can't get a hold of them, what steps you've taken. One's got to present to the master all the available mental health care related certificates and reports. That would mean stock standard, somebody like having a medical report from a geriatrician, a neurologist, a psychiatrist, somebody like that, to explain what it is, what the diagnosis is, what the mental health status of the person is, and whether that person has the capacity to manage his or her own affairs. You then submit this application to the master. Now, one aspect you also have to, of course, in your application, set out particulars of the patient's patient itself, the patient's property and the value of that property, assets, liabilities, and the annual income. And what the value of that annual income. And the values of those things are relevant for, as I understand, the purpose of the master's decision whether or not there should be a further investigation. Because once you've made application and you've given notice of your application to the patient, it's submitted to the master, and the master then may appoint an interim administrator pending an investigation, or he may appoint a final administrator without the necessary, without an investigation, if the estimated property value of the patient is less than 200,000 Rand and the annual income is less than 24,000 Rand per year. And the master is happy that there are good grounds. Now, if the master decides that there ought to be an investigation, he then appoints what I understand is usually somebody such as an attorney to do an investigation, to investigate the merits of the application. That is, whether there are specific allegations in the application that needs to be confirmed, whether there's further information required. In fact, what the value, estimated value of the patient's property and annual income is. And then the investigator charges a fee for that. That fee is paid from the patient's estate, generally, unless the loved ones, the applicant, decides to pay for it. So that investigator may summons any person to provide information and documents, and may inquire about that investigator may inquire about the financial position of the patient. Now, once the report is submitted to the master then has 2 weeks to either appoint a final liquidator, decline to appoint an administrator. What did I say? Appoint an administrator, decline it, or the master may refer it to the High Court, to a judge in chambers. A judge in chambers, that is a judge sitting in his or her office, not in open court. Now, the administrator then takes charge, so to speak, of the patient's property, may make payments if there are monies to be collected, to collect those. But under the auspices and the supervision of the master, the administrator must file annual accounts with the master to say, this is explained exactly in the legislation and the regulations. The two are clear as to what must be contained in those accounts. And that is the process. Now, once a final administrator is appointed, that person, that administrator, is entitled to raise charges. But those charges are prescribed by the Administration of Estates Act. And as in fact, a lot of people are very concerned about what such a person charges. It's the same whether it's an administrator or a curator to the property, of the patient appointed by the High Court. Those people are only entitled to the charges laid down in the legislation, and that is 6% of the income collected and 2% of the value of capital assets upon distribution or payment or delivery. That's right at the end. So that's the process under the Mental Health Care Act. I had a fruitful discussion with an attorney recently who does a lot of this work. He is well known to the master. There's another aspect that is very important for an administrator, also for a curator, and that is that, again, in terms of the Administration of Estates Act, this act, the Administration of Estates Act, regulate things such as the powers and duties of executors, those that are appointed to administer a deceased estate, tutors, that relates to children, curators, and administrators. Their duties and powers are set out in the Administration of Estates Act. It is always under supervision of the master, and importantly, the master must require, unless the court exempts, such a person to set security for the due fulfillment of his or her duties. And this is often where a problem comes in for laypersons. Attorneys have, by virtue of them being attorneys, they must have fidelity fund certificates. That's a type of professional indemnity insurance. So financial people, accountants, chartered accountants, also have professional insurance, indemnity insurance. So if something goes wrong, it's a type of insurance that'll pay out. And that's really what the master wants. I was told by this attorney that there are only 4 or 5 insurance companies in South Africa who are prepared to give such deeds of insurance, of security, to the master. So it's not always easy. And the premium payable might be, what it is, I don't know. Because it depends on how big the estate is. But I'm told that each of these assurance companies demand proof of experience of administering estates. And then I'm told the value is 0.006% of the value of the estate. Sorry, I'm just seeing here about powers and duties. Let me powers over. Oh, you see, property does administrators have powers over all financial assets? Yes, because that's the point. You collect money, it must be invested, it must be you've got to, as an administrator, there has to be an estate account, banking account. So a separate banking account must be opened. And those are, for instance, in the annual accounts that you will submit, an administrator is to submit to the court, to the master. You will have to demonstrate what came in, what went out, that sort of thing. One must be careful. I haven't had the opportunity to read the entire judgment, but there was a recent judgment about, yes, in the context of road accident fund matters, and where trustees or curators are appointed there, taking fees for investments. I must still consider that, whether that's possible, but ultimately, when in doubt, ask the master, as an administrator, as a curator. The master, the people in the master's office try their damnedest, so they'll get back to you. It might take time, and sometimes you don't have the time. When in doubt, ask the master. I'm told that it's, because I don't get there, it's not in my field of practice. One can in Johannesburg with a master here relatively easily obtain access to the office and some person with a face and a name to ask your questions and get authorization. So that's the administration of an administrator. As I say, by all accounts, the Mental Health Care Act applies to a very limited category of patient, those with mental illness or severe or profound intellectual disability. Then comes the alternative, and that is a judicial declaration of incapacity in terms of the common law. When it affects one's status, legal status, until relatively recently, it was only the High Court who could pronounce on that. With the introduction, for instance, of the regional court and the magistrates court being able to grant divorces, that's now something else, but it's very strictly regulated. But in terms of the common law, the High Court can pronounce on status. And being declared incapable of managing your own affairs is a severe and drastic curtailment of legal status. As such, the process is relatively involved, although not difficult. Yes, it is more expensive because it involves an application to the High Court, and it involves a two-pronged approach. I have far more experience about in matters of this nature than in the Mental Health Care Act, so I'm better able to answer questions on this. Now, when it comes to an application to have somebody declared incapable, it is in the High Court. You bring an application as applicant. It is brought in terms of Uniform Rule 57. It's not relevant, but Rule 57 of the High Court. And it involves, firstly, the first prong is to ask a court to appoint what we call a curator ad litem, a curator to the legal proceedings. This is a person, an advocate, unless somebody is on the platteland somewhere and an advocate is not close by, then it can be an attorney, but it's generally an advocate, is appointed to investigate the allegations in the founding papers, in the application, to interview the patient, to interview relevant people, the doctors, and I'll explain all what is required there. So really the curator ad litem takes the same role, if you will, as the investigator that the master may appoint in terms of the Mental Health Care Act. Once the curator ad litem's report is at hand, the curator ad litem must also interview the proposed curator to the property, curator bonis to the property, and if necessary, a curator, whether it's necessary, and if so, who is to be appointed as a curator to the person of the patient. That report is then filed with the master. The master then files a report. All of that is placed before a court for a second hearing. And in the second hearing, the court then determines whether or not, one, the person is of unsound mind or otherwise incapable of managing his or her own affairs. That's a formal declaration. And then secondly, the appointment of a curator to the property of the person, including setting out all the powers, and if needs be, also the appointment of a specific individual as the curator to the person of the patient. Now, when bringing an application, one has to, as an applicant, set out on what basis you as applicant have legal standing. That is, whether you are a child, a sibling, a spouse of the patient, why you say the court has the authority to hear the matter, that's jurisdiction, and that's more often than not because the patient lives within the area of jurisdiction of the court. So if somebody lives in, I know it sounds weird, Johannesburg or Pretoria court can listen to the matter, can determine the matter. You must set out your relationship with the patient and the duration of that relationship. Facts and circumstances why you say, as applicant, to show that the patient is of unsound mind and incapable of managing his or her own affairs. The application, you must set out who you believe ought to be appointed as curator ad litem, whose counsel to investigate, and that person must sign written consent to act as such. And then also who you believe ought to be the curator to the property and, or, well, to the property, and if needs be, to the person of the patient. And again, each of those individuals must give written consent to act. The application must be supported by at least one person to whom the patient is well known, and information containing information and facts which that person has of own knowledge. So not somebody's story, own knowledge regarding the person's mental condition. And then you need the affidavits of at least 2 medical practitioners, 2 doctors, of which at least one is a psychiatrist. In the old terms, they used the word an alienist, and nobody knew what an alienist was. It's a psychiatrist. Or another medical practitioner with appropriate experience. I find with patients suffering from vascular dementia, for instance, is very often rather a neurologist and a geriatrician than it is necessarily a psychiatrist. Bipolar disorder can lead to terrible things. That would be a psychiatrist. So those 2 doctors must file reports, which they must confirm under oath, stating that they've recently consulted with a patient, their diagnosis, prognosis, and what they believe, whether or not that person is capable of managing his or her own affairs. So now that curator ad litem is appointed, there's this investigation. In my practice, I try and interview as many people as I can, especially loved ones, close family members. I speak to all the doctors whose reports are already on the papers to confirm that that is in fact so. I interview the patient insofar as that is possible. And then I do my report. I will talk to also the proposed curator to the property. I will talk to, if needs be, the curator to the person. That report is filed. The master has its say, and then the court decides. Now, fundamentally, a curator to the property is appointed to take care of the patient's property and income and expenses, and to supplement that the patient's capacity to contract. The master has a precedent of the various powers and duties to be awarded to a curator bonus, because unless the court authorizes that person, that curator, to the property with these powers, he or she can't perform it. So it's very important to make provision for wide powers. It is to receive, administer property, to carry on any trade or business or undertaking by the patient, to acquire movable or immovable property to the benefit of the patient. Remember, it's always about the patient. The curator bonus may let or even sell property, to perform any contract, and to apply any income or capital of the estate of the patient to the patient's maintenance, support, or benefit, to incur expenses on behalf of the patient, to expend any income or capital of the estate of the patient on the maintenance, education, and advancement of any relative of the patient, or any other person wholly or partially dependent on him. So where somebody is incapacitated and they are still, it's not necessarily an older person, but it could be grandchildren who still need to go to school and be paid, and Oma and Opa has always paid it, then the curator bonus may very well pay that. To invest money, and then also to institute any proceedings, legal proceedings, which may be necessary in the interests of the patient. As I said before, that's basically also the powers of an administrator. And there is no limit on how large the estate is when it comes to the High Court. I saw Nicoline, I'm reading there. I'm hoping, yeah. For administration, in fact, there is no limit. I thought there was, but there's not. The limit, the 200,000, 24,000 Rand income is a limit when it comes to whether or not there should be an investigation. That's the value. So the curator to the property, again, must exercise powers subject to the approval of the master, must file annual accounts like an administrator, and must obtain the master's prior consent to certain transactions, such as the sale of a home or the encumbrance of a home, taking out a mortgage bond. All right. Again, the charges of the curator bonus to the property is prescribed. 6% of the income collected and 2% on the value of the capital assets only on distribution. Again, the curator to the property must set security to the satisfaction of the master for due fulfillment. And this is where the difference comes in administrator and curatorship in terms of a court order. The High Court can grant an order exempting the curator to the property from setting security. I've seen that before. I have recommended it before, but it's only the High Court that can make that order. Now, there's a third possible curator involved in a judicial declaration, and that is for the appointment of a curator to the person of the patient. When appointing somebody like that, it is a serious inroad on the personal liberty of the patients, and courts are sometimes reluctant unless the circumstances clearly require it. Now, a curator to the person, again, must be bestowed specific powers and duties, and these include to attend to the needs of the patient's daily conditions, to take care of the patient's well-being and safety, psychosocial needs and any intervention that may be required, to ensure that the patient receives medical treatment and or medication or any other treatment in connection with the patient's health. So that's in terms of the think back of the National Healthcare Act. That's a curator to the person of the patient that is only appointed by the High Court, not the master, in terms of the Mental Health Care Act, to determine where the patient should live and make arrangements to move the patient to such a residence, including admitting the patient to an institution for the elderly or infirm. It might be necessary sometimes for the curator to the person to collect medicine from a pharmacy. That's the job of the curator to the person. I was involved in a matter very close to my heart, a person who was in fact a lecturer of mine at university, who became impaired. And he had 3 children. He has 3 children. He's a cantankerous man, has always been, and as the impairment grew, he became even more cantankerous. And we then decided, and it's worked like a bomb, to appoint a curator bonus, an attorney, properly so called, to his property, and then a social worker was appointed as the curator to his person. And she, in conjunction with the children, makes certain decisions. But ultimately, it was about retaining and protecting the relationship between father and children, so that it didn't fall on the children to make the difficult decisions of placing him in an institution. That's that other person, that woman. And I thought it was a brilliant idea, and so far it's worked very well. Now, there are certain legal acts which are so personal that neither a curator to the property nor a curator to the person may perform on behalf of the patient. That, for instance, marrying. You can't enter into a marriage on behalf of your patient. You can't ask for a divorce. You can't exercise parental rights and responsibilities, and you cannot make a will. If the will is there and the person is impaired, sorry, it stands. As a final, the costs of both the curator to the proceedings, the curator to the property, and the curator to the person, if appointed, is paid from the estate of the patient. The law in South Africa is difficult. It takes time, it takes money, it is confusing. And it doesn't cater for older people. People who grow older because the medical advancement is such, but the law lags behind. It is emotionally agonizing for the loved ones, because one is so scared of upsetting your parents, your grandparents. But there are ways and means, and let it not be said that we do not care for our elderly, with whom we are, after all, nothing. Thank you very much.
Thank you very, very much for so much information, so insightful, really, really lots of stuff to think about. Yes, if they weren't there, these older people, we wouldn't be here, so we should be thankful to them. There's something I would like to answer. When somebody is rendered as incapable or is viewed as incapable, sometimes they still have decision-specific abilities, to make decisions about specific. So I'm thinking of somebody who no longer can drive. She forgets that she can't walk, but she knows exactly what goes on in her finances. So, you know what, to get a curator for her while she's actually still capable to do it herself. Although, because especially if people have strokes, you know, if there's vascular dementia, it differs it depends on where the actual problem in the brain is. So how do you handle that?
Well, I had a matter where the patient, I was curator at Litem, the patient indeed had vascular dementia, and terribly cantankerous also, as they become regrettably with vascular dementia. And he insisted on driving, but he was crashing the car left, right, and center. And fortunately, well, his daughter explains, fortunately, COVID struck, and they took out the battery of the car, and then said to him, "Sorry, the battery's flat," and he stopped driving. But that's not a legal issue. That's not a, I believe that's not a curator. A declaration of incapability is not the answer there. That's when somebody, it's a question of, you still understand what your finances are. These are my bills. This is what I need to pay. This is how I do it. Some people might not be in their older age as au fait with online banking or cell phone banking or WhatsApp banking. They go into the branch, but they can still do what they do. Yeah. And it's okay. You also, because one is declared incapable, doesn't mean that I can't decide what I want to eat.
Yeah, of course.
Or which TV program I want. That's also a decision. But it's in the legal context where things go belly up. And it makes it difficult. It is generally, ultimately, it is a medical question that medical experts must give that information, whether or not somebody is, the impairment is so bad or such that they don't understand, they can't manage their own affairs.
Yeah.
And then dementia, there are better days and worse days. Those lucid moments.
Yeah, those lucid moments.
Those lucid moments. Sorry, somebody here, Mark, you asked whether it's required to have an attorney to make the application. As I understand it, no. It's not necessary, but it would probably assist. You know, one can, yeah, good luck if you want to go stand in the queue at the master's office. But yes, you don't need it, but it's probably advisable. I find it's generally advisable too, because it's a big decision. And just because it's an easier process from a procedure point of view, doesn't necessarily it's the right answer, right alternative in the circumstances.
The previous question there is, please, can you clarify the requirement for security? I'm not sure what it means.
All right, security is effectively, call it insurance. Insurance that is given to the master, that you as administrator or curator is going to do what you need to do properly. i.e., if some person with less integrity than he ought to have steals money, the master can look to the insurer to recoup the money. It's a type of insurance, security for due fulfillment. I'm not aware of precisely who the four or five insurers are. That's not something that I generally deal with. I do know when it's an attorney, it is easier because attorneys have fidelity fund insurance. And then it might be that in certain circumstances, the masters say, all right now, I don't need security. I'll give you your letters of authority, because without that, you can't act. Yes, the court appoints you, but the master must give authority, the letters of authority. So I'll give you that, but in the meantime, you don't. But for instance, when an administrator is appointed, there is only a home. You can't really do much with a home. But once that property is sold and there's cash, then the master says, give me security, because now you've got cash. So anything else? Did I miss something? So administration, yeah, Nicolene, you asked earlier, so administration actually does not cater for the person precisely. In terms of the Mental Health Care Act, it is solely the property. So that's where it becomes difficult. I would hazard a guess that an administrator could, for instance, enter into a contract with an institution for elderly residents, such as Ekklesia Park, but that's the contract, that's the property bit. The actual consenting to medical treatment or to an actual move, that's personal. That's to the person, and that would be a curator to the person. But then, as I said, some of the legislation does provide for here and there certain personal acts that can be where consent can be by way of a surrogate, an agent, for somebody else.
For the poor lady on the street who's got no money, no anything, she needs to go to an old age home. There's actually nobody who's got any.
Well, apparently then SASA can pay the $500 or whatever they pay these days off to that institution, and I mean it doesn't cater for anything. But anyway, yeah.
No, that's just.
Karen, can the curator to the person and to the property be the same person? Yes, it can. Is it advisable? Probably not. But yes, it can. Yes, it can. I've had people like that, yes. But you need all right, we'll end now. Ultimately, for a curator, specifically, because that's where my experience lies, you need the buy-in of everybody, all the family. Otherwise, there are terrible fights because it's other people's money and people are fearful.
That's the bottom line with dealing with people with incapacity. They must all get together. So I think I would just like to add to Sanetta Lange, who said, thank you for the detailed, informative presentation. We as family members of the impaired elderly people really appreciate. And I think we couldn't have asked anybody more informed than you to assist us with that. Thank you very much. Okay.
Thank you so much, everybody. Have a wonderful day. Bye-bye.
Bye-bye.